Okay, so we'll get started. Thank you everyone once again for joining in the webinar today. Today I'm joined by Prashanthi Reddy. Prashanthi, just to introduce her a bit, she has attended the University of Pennsylvania Law School in '96, and she has experience in the immigration field since 1997. She was admitted to the bar in New York. She's also a member of the American Immigration Lawyers Association and the New York Bar Association. She has held the position of the immigration chair for the National South Asian Bar Association and the immigration co-chair for the Federation of Indian Associations. She's actively involved in pro bono legal work and volunteers for various organizations. She has been voted as the top 100 lawyers by the National Advocates. She has been selected as a top 100 immigration lawyer in the state of New York by the American Society of Legal Advocates and as the 10 best attorneys in New York by the American Institute of Legal Counsel. So there you go. That's a lot of credentials and a lot of backing and background. And on that note, I would like to introduce Prashanthi. And Prashanthi, the floor is yours.
Thanks, Vishal. So if we can go to the first slide without any more ado. So we're going to be talking about immigration updates, as we always do, but there's always some updates with reference to immigration, and I like to keep our listeners up to date on, the current events that are happening. Also, focus for this week will be H1-B registrations because the registrations are coming up. As we all know, registrations open up once a year in the month of March, and they close, in 15 days. So we need to get geared up and ready for all those people who want to file registrations, whether it be employers or employees, people in India or elsewhere who've never been on a H1. This is your chance to file a H1B registration. Students, people on F1 or people on other statuses like H4s, B2s. Again, for all of you, this is your opportunity to file your H1B registration, and there's a very small window of opportunity to do so. So this, I thought it would be appropriate to talk about it, about H1B registration this month. So let's first start off with some immigration updates. As you see on your screen, the USCIS has proposed a fee increase. It's not yet done. It's a proposal, and they're waiting for comments on it. It's been published in the Federal Register. They wait for comments until March first week, and then which is 60 days. And then they look through all the comments and then decide on what the course of action should be. But the proposal is such, and I'm just talking about the highlights here. USCIS proposes to charge a $600 fee for employment-based petitions. So the I-129 H1s, the I-140s, L1s, so all I-129 non-immigrant visas and the I-140 immigrant visas to help cover the cost of asylum cases. So they're trying to, since asylum work, the asylum program, a lot of it is not fee-driven. They're trying to cover the cost of the asylum program with the employment-based program. So that would increase the H1B fee and the I-140 fee to $600. In addition to that, the H1 non-immigrant workers fee, which the basic fee is $460 right now, with a bunch of other fees added on, which comes to about $1,700 to $2,000 with all the other fees. But the basic fee is going to increase from $460 to $780. So as you can see, the increase is close to $900 for the H1B petitions, and $600 for the I-140 petitions, and for the other I-129 applications such as the O1, the L1, etc. Another increase is EB-5 investor program. They've increased it threefold or more, fourfold, It's from 3,600 to 11,000. They've increased it. So that's your increase for EB5. EB5 is the investor visa, where you put in 1 million or $500,000 and hire 10 people, and you get a green card eventually if you qualify. The family-based immigrant applications have not been spared. The fiancé visa has increased from 535 to 720. And other family-based green cards, like if you're filing for your spouse, you're filing for your parents, your brother and sister, it is presently 535, and they want to increase it to 820. So you can see almost double. And the H1-B registration that this webinar is mostly about, they want to increase that fee 200-fold, really, from $10 to $215. Lucky for us, that increase to $215 will not apply for this year, because it's too late for them to apply it. So let's see what happens next year with the H1B registration fee. Next slide, Vishal. Another important update is that there was a major settlement. There was a lawsuit, and there's a major settlement with reference to adjudication of H4, H4 EAD, and L2s, together with the I-129, which vastly improves processing time for H4 EADs, and L2s. So they want to process the H4s and H4 EADs alongside the H1B approvals if they're filed together. Previously, that's what they used to do. But then what happened is they put in a biometrics requirements for all I-539 petitions. So for all H4 petitions and 765 petitions, which is the H4 EAD, they had a requirement to do biometrics. So they were not able to process the H1 and the H4 together anymore. And then one thing led to the other, and the H4 processing time and H4 EAD processing time jumped up to almost a year, to more than a year, actually, so a year and a half at one point. So what was happening is a lot of H4 EAD people who are working on EAD lost their jobs, because no employer is going to wait for that period of time for them to start working again. So this is good news. They've gone back to the old formula of processing cases H1s and H4s together, which means the processing time really has been reduced to a few months, and reduced to 30 days if the H1 is premium processed, because they plan to process both cases together, even though there's no premium processing for H4. Since there is for H1, and since the processing is together, they will most probably process both the cases in 30 days, because that's the premium processing time, which is fantastic news if you're filing together. If you're filing separately, then again, there's a processing time, but there's good news there also, because the processing time really for H4s has improved significantly from last year. Next slide. Another quick thing that I wanted to talk about was the public charge law. There's been some changes with the public charge law. What is the public charge law? That is something that applies to people who file for green cards. So tomorrow your I-140 priority date becomes current, and you're filing for your 485 along with your family members, or say you're filing a family-based petition for your parent or your spouse. They will make sure that the person filing the 485 will not be a public charge. So they try to estimate or guesstimate whether the person will become a public charge or not. And the way they do that is by looking at what previous assistance or benefits, public benefits that the person took. So the public benefits, what has changed is that the allowable public benefits, which a person can take, and they will not be determined to be a public charge, and the benefits that a person can take and then will be called a public charge. So what is allowed and what is not allowed in benefits, so that the public charge rule doesn't affect you when you're filing a green card. So basically, the benefits that are not considered for the public charge purposes are food stamps. People take food stamps, health insurance, children's health insurance, which is provided by the government, Medicaid, unless that Medicaid is being used for long-term institutional use. So you join in some kind of a home, whether it be an old age home or physical therapy place, where you need long-term institutionalization to take care of your ailment, then that would be considered a public charge if you use the Medicaid there. But otherwise, Medicaid generally is not considered a public charge. Housing, if you take housing benefits, if you take the vaccine, which we all know is free, any disaster or pandemic assistance that you get, during the disasters, during 9/11, during Katrina, people were given disaster benefits. So that would not have been considered to be a public charge. Free lunches for children, school lunches, is not considered to be a public charge anymore. Childcare assistance, etc., etc. So anything that's non-cash, is a non-cash benefit program, is not considered to be a public charge. So let's see what's considered to be a public charge then. Next slide. Public charge, basically there are two important benefits that you cannot take if you want to file a green card. First is getting cash, getting income assistance, and that income or that cash is pretty much being used as your primary source of income. So if you have done that, then you're most likely going to be considered to be a public charge. Long-term institutionalization at the government's expense, including using of Medicaid for that purpose, which I was just talking about. These two would be considered to be a public charge. So if you've taken one of those two benefits previously, then you're likely not to get a green card, but it all is not lost. They do look at the entire circumstances. They look to see if there is the person that's sponsoring you, whether they have enough money to sponsor you, etc., etc. So, it doesn't look good for you if you took these benefits, but they still look at the whole picture. So it's important to speak to an attorney to see whether you qualify for a green card or not. Next slide.
Sorry, Prashanthi, just a quick interruption before you move to the next slide. A gentle reminder for everyone here. We will be conducting a Q&A session by the end of the presentation. So please keep all your questions handy, and you can either drop it at pretty much any time during the presentation, or you can leave it at the very end, and then we'll pick up on it.
Thanks, Risha. Let's now, before we start the H1 registration process, I did want to give you guys another update, which is fresh off the press because it only happened yesterday and we didn't have time to include it in the slide. But there was a legislative action taken yesterday. So a Democrat did introduce a bill into the House, whereby the bill talks about giving representation to people that are stopped at CBP. So basically what it is if you're stopped from entering into the US, even though you're on a H1, sometimes you're maybe on a B2 or an F1. So whatever status you're on, sometimes the officers at the port of entry can stop you, ask you questions, keep you for a long period of time, sometimes without food and water, unfortunately, and interrogate or question you. And you don't have the opportunity to speak with an attorney at that point of time. So there is a bill introduced whereby you can contact your attorney or contact someone, your employer or whoever it is you want to contact to get the information that you need to represent yourself better at the CBP hearing at the port of entry. I've seen a lot of cases where students were sent back because they found something or didn't find something on their social media, or some question was asked and not answered properly. The same thing with H1s. They do have the right to enter into the United States because they do have a visa. And so when they're denied entry, there has to be good reasoning behind it. And oftentimes there's no one overseeing that to see whether the reasoning is sound, or, if it's based on something else like racial profiling, etc., etc. So that, which is very possible if, the person doesn't have any representation. So that's what the whole bill is about. And the same bill will be introduced in the Senate as well. This is being reintroduced. The last time it was not acted upon. So let's see. It's an important bill. Let's see if it's acted upon this time. Now moving to the H1B registration process, I wanted to go through how to on H1B registration process so that those employers out there who are watching this webinar have at least a basic understanding of how you do a registration. Even if you're not doing it yourself, or if you're doing it yourself, whatever the case may be, just get a basic understanding of how to do it. So the first thing you have to do is you have to go to myuscis.gov and you have to sign up. Give your email address, create a password, create a secret question, all that stuff, and do the create a two-step verification method. So depending on what you select, in order to enter every time you seek to log into the system, it'll send you either a text message with a code, or it'll send you an email message depending on what you decide. And then you enter that, and then you're allowed to log into the system. So the first thing that you have to select when you enter the system is, I am a H1B registrant. Don't select I am a H1B petitioner, because that sounds like the most logical thing to select, because you are a H1B petitioner, you are an employer. But remember what we're doing right now. We're doing the registration. We're not filing the H1 online because it's not possible to do that as yet. So you have to select I am a H1B registrant, right? And then you get two boxes, either to start a registration on your own, or if you're using an attorney, you would have sent all your information to the attorney after you opened, registered yourself. You have to send all your information to the attorney. The attorney will enter all the information for you. And so at this point, you will click, you've received a passcode from your attorney or representative. Then you enter the passcode, you review and accept the G28, right? And you finish and send. You sign, finish, and send. And then the attorney will take it from there and actually submit your registration. But if you're doing it yourself, then you would say that you would want to start a registration, then you would enter all the information that's required to start a registration. Let's go to the next slide. We can look at the information that's required. Now, this is the information that's required from your employee or prospective employee. The legal name, so the full name of the beneficiary. Make sure you don't make any spelling mistakes here, because if you do, then and the case gets picked, and if the names are not matching on the I-129 petition and on the registration application, they can question if it's the same person or not. And then you'll have to provide additional information to show that it's the same person. The gender, if they are eligible for the US Masters quota, please make sure you click this, because you fall under a different quota, a different 20,000 cap scenario. So make sure you click this, because your opportunities are much more. Then you have two lotteries for you. You'll be selected, you will be put under the Masters lottery, and then if you're not selected, you'll be put on the regular lottery. So you get two opportunities. So make sure you do click the Masters H1B quota. Remember, to be qualified for this, you have to have, or you have to at least have completed all the requirements towards your US Masters. And even if you don't have a degree, or you should be able to anticipate that at the time of filing the H1, you would have completed your US Masters by then. You need not have completed it during the registration, but definitely at the time of filing the H1, you should have completed your Masters. So if you know that you're going to do that, if your employee is going to complete, then you can definitely select the Masters quota. Date of birth, country of citizenship, passport number. Now this is optional, but I urge you to fill out the passport number for each of your employees, because if there is, for example, two people with the same name or very similar names, USCIS might treat this as a duplicate petition. As you know, you can only file with one registration for one person, and they might then deny that petition because they think that it's the same person. But if there's a passport number, which is the identifying factor, then they will know that it's two different people. So I urge you to fill out that passport number in your registration application. Next slide. Let's look at what information is needed from the company. The company requires, you require your name, your DBA if you have one, your FEIN number, or SSN number if you're not incorporated as a company, your US address office. Remember, if you move after you file your registration, then you should make sure that you have proof that you're still the same company, you're just at a different location. Then you would show proof of address at the time of filing your H1B petition. So they want to make sure at every given point of time that you are the same employer and the applicant is the same applicant that has registered. Now, some of the do's and don'ts, what to do and what not to do during a registration. I think some of the things we've already discussed. But if you've already have an account from last year, now is a good time to log in and check if that account is active as yet or not. The H1B CAP petitioner has to create their account before your attorney starts her registration. Like as I said, first you go and create your account and then share that account information to your attorney. Attorney enters all the information and then you follow the rest of the steps. Select I'm a H1B registrant. I already told you this. Don't select I'm a H1B petitioner. Make sure you select I'm a H1B registrant. Next slide. The email that you use to register, you have to give that same email to your attorney. If you give a different email, then the attorney will register, but that information will not sync into your registration. So they will not be able to complete the registration. So make sure you're giving the same email address. Make sure you fill out the proper names for the beneficiaries. Last name, first name. Don't use acronyms like FNU, LNU, etc. Use the drop downs that the system has. Just a reminder, LCA is not required for you to file a registration. You file the LCA later on, but you do need to review all the documents to make sure that the person qualifies, because you say you're doing filing a registration and then later on the person doesn't qualify for the H1. Or doesn't qualify for that particular job title, then you're wasting a registration and the whole process will then be wasted. So you want to make sure that the beneficiary qualifies, you go through the beneficiary's documentation, that you qualify as an employer, so that you don't waste a registration. And also the USCIS can question you as to why you registered and didn't actually file the petition. So that's something to keep in mind. You don't have an option to edit once you've submitted your registration, so make sure that all the information is correct before you hit submit. Clear your cookies regularly. Make sure you don't make a mistake with the name of the beneficiary, which we already went through. Next slide. I wanted to go through a quick timeline of what to expect for this registration period. March 1st is the start date for H1B registrations. March 17th is the last date to submit registrations. Remember, March 1st noon is when registrations start, and March 17th noon is when registration stops. So it's not March 17th end of the day or March 17th 12 a.m. It's noon, 12 p.m. March 18th to 31st is when the lottery takes place and the results start coming in. So by March 31st, you should have all the results in. And then April 1st is when you file the H1B registration, and you have 90 days to file. So June 30th is your last day to file your H1B registration. Next slide. So just an outlook of what to expect this year with reference to registrations. So I've given you some numbers for the last 3 years. So in 2021, there were 274 registrations, and we had 2 lotteries. So the first lottery, 106,100 were picked, and then the USCIS decided that not enough people filed. After filing a registration, they didn't actually file the H1. So they had a second smaller lottery, and 18,315 registrations were picked. So that gave them a grand total of 124,415. So about 1/3, slightly more than 1/3 of the cases were picked. Now in 2022, 308,000. So this is for last year I'm talking about. I mean the year before last, 308,613 H1 registrations. So you can see significant, well, about 30,000 more registrations, not that significant. Initially selected 87,000. There were 3 lotteries done because each time not enough people filed H1s after filing registrations, because as we know, there are a lot of duplicate registrations filed by beneficiaries. They file 5 registrations, 4 registrations, so that they can increase their chances of getting into the lottery. Remember, an employer cannot file multiple registrations for the same person, but the beneficiary can file multiple registrations through different employers. So that's how they get around this rule. So they conducted a second registration in July and picked up 27,000. Then they picked up 16,000 after that in a third registration. So total 131, almost 132 cases were selected. About 1/3 again of the cases were selected. So quite similar to the year before. But something different happened last year. The number of applications almost doubled, about 500,000 applications, registrations. And so the pick rate, obviously, there was only one lottery and they picked 127,600 registrations. So about 1/4 or 1/5 only of the registrations were picked. So the pick rate was much less because the number of people filing was much, much more. So what will happen this year? We were thinking if the number of registrations increase, and obviously the pick rate is going to decrease. So we're expecting more registrations this year. I don't see why they shouldn't be either the same or more than last year. We were hoping if the fee increased then to $200, then maybe less people would register. But since that hasn't happened, I don't see any difference from last year to this year. So we can expect the same number of registrations. And now quickly to talk about RFEs. Now you've registered, and we'll talk about RFEs very briefly because we're going to talk about it more so in our next webinar. So very briefly, why would you get an RFE? So you filed a registration, it got picked, you filed your H1. So what do you do when you're filing a H1? How do you avoid RFEs? Because we all want to do that because it saves us time, money, and the chances of getting an approval are more if there is no RFE. So the most common reason to get an RFE is the specialty occupation reason. So when you choose a job title which is not a specialty occupation, you haven't done the research to see if a bachelor's degree in a particular field is required for that job or not. There are many ways of doing that research. You can go to the Occupational Outlook Handbook, which is a Labor Department publication. You can go to ONET, which is also a Labor Department publications, and they tell you for each job title what is the requirement. So if it says bachelor's in computer science, for example, then it is a specialty occupation and you can proceed forward. But even after doing this, sometimes you can still get into trouble with specialty occupation because the duties that you've mentioned may be very simplistic. So you say software engineer, but the duties that you put in are testing duties or coding duties. There's no developing, designing, that kind of language in it. So then the officer will send an RFE saying that you put in software engineer, but the duties seem to be more like a programmer, a computer programmer kind of duties or tester kind of duties. So it doesn't seem to be a specialty occupation. So be very careful when you're preparing your petitioner letter to include the proper duties when you're sending out your H1 to the USCIS. Next slide. Another reason or another way to avoid H1B RFEs is make sure there's availability of work. Your work cannot be speculative. You cannot say that once I hire the person, then I'll look for a job for that person. So you have to submit availability of work or proof of work with your H1B petition. So if the person is working for an end client, if you're an IT company, then you would put in the PO, you would put in the MSA, you would put in a vendor letter, maybe an end client letter if you have one. Anything to show that you actually have work for the person. If the person was working on an in-house project, again in an IT situation, then you would put in the project information, the cost analysis, marketing analysis, the contracts and invoices maybe that you have from clients that are using your project, uh, or the people, if you've outsourced your project, part of your project to someone else, maybe invoices that you're getting from them for having developed part of the product. So, there are a lot of ways of showing a product, but just a note of caution. A lot of people put in-house project because when they don't have work for the employer and they want to basically find work for them or market them after they get onto their payroll. So USCIS is very well aware of this. So I would caution you against using dummy in-house projects because USCIS will then question them and your case might get denied. So just be careful when you're using in-house project. If it's genuine, then there's no issue because it's easy to show it if it exists. I guess we're done. So
Yes.
Over to you, Vishal.
And now we are opening it up for Q&A. So what you can do is if you have your questions, please, now is the time for you to put it on in chat and we will pick it up. All right, so I have one question. I have finished. Okay, I just have to paraphrase it here. The person has finished masters in, or finishing rather, masters in May 2023. Please advise if we can go for H1-B registration.
Yes, you can, because even though at the time of registration you have not finished your masters, and the end date, remember, to file registrations is June 30th. So if you file after you finish your masters in May, you still have the opportunity to file in May. So as of the date of filing, as long as you have completed your masters or you have completed all the requirements to towards your masters, you can still do your registration under the masters cap.
Okay, great, that helps. Another one of the frequently asked question is there an appeal process for registration determined to be invalid duplicates?
So no, unfortunately, if your registration is denied due to either the fact that maybe your payment didn't go through, you have to put in a credit card for the $10 fee payment, and maybe it went through initially, but then your bank rejected it, and that happens. So you have to talk to your bank before you start your registrations. But you can't appeal it. Or sometimes if it's a duplicate, or maybe they think it's a duplicate because, as I said, some names may be similar and you don't enter a passport number and they reject it, there is no appeal process.
Okay. At the time of registration, do we need to give the client details?
No, you don't actually. You have to give just basic information at the time of registration. So I know a lot of companies, what they do is they file a registration, and once it gets picked, then they start marketing the candidate because they have 90 days to file their H1. I mean, eh, people do it, but then you're under a really short time constraint. So you have to make sure you file before end of June. So yes, it's possible to file without the client information. You don't need to give any of that information when registering your case.
Okay, all right. I graduated with my master's in computer science degree in December 22. Can I file H1 for me and H4 for my spouse together? Is there any special process for students?
So yes, I mean, if you're filing for the first time under the H1-B cap, you file a change of status, and obviously you are cap subject. You file a H1-B change of status from F1 to a H1. The filing of the H1-B petition is the same. You can file together with your spouse. So your spouse will file change of status from F2 to H4. I know you say that your F2 visa was rejected, but this is not a visa. We're filing a change of status. So it really, the rejection at the consulate really has nothing to do with filing because you're here filing the change of status for you or your spouse. So you can file a change of status. Is there any special process? No, it's just a change of status from F1 to H1, but you do get some special benefits if you're a student, because there's something called the cap gap law, which allows you to remain in that particular status you were in at the time of filing the H1. So say you are on OPT at the time of filing your H1, and subsequently, because the H1 processing takes time, your OPT expired, but you're considered to still be on OPT and you can continue to work on a OPT because of the cap gap laws. So there's some special status that F1s have when they file.
Okay, great. The next one is an interesting one. If candidate applied with 2 employers, both got picked, what will be the next steps?
Well, then what's going to happen is that the person will decide, the candidate will decide which employer they want to go with. And the other employer simply doesn't do anything, because there's no requirement by USCIS right now for the employer to give them information as to why they didn't file after registration. The USCIS can come back and ask them why they didn't file the registration, but that hasn't happened. I mean, when registration first started 2 years ago, they put in a lot of information saying that if you don't file the registration, you'll be blacklisted. We will ask you the reasons why you didn't file, etc., etc. But that never happened. They seem to be just ignoring those people who didn't file. So really, I don't think anything much will happen even this time. Let's see, who knows? But so the employee will basically choose the employer that they want to file the registration with, and the other employer will simply not do anything, and the registration will go to waste. But I guess what USCIS is doing is they're picking enough registrations to take into factor the duplicate filings as well.
Okay, great. Well, Prashanthi, there's a follow-up question on this. Question is, what will be the cost for withdrawal fee for H1B registration?
So there's no, as I said, there is no procedure right now to withdraw a H1B registration once approved. So there is no fee for it and there's no procedure for it.
In the meantime, Prashanthi, I'll add another one of those frequently asked questions I have here. Will the system allow for multiple members of staff to log on to my account at the same time?
Yeah, that's a very relevant question, actually. So unfortunately, the system will not allow that. But they can, of course, anyone can log in. It doesn't have to be one person. And you can log in from different computers or different parts of the world. But you have to use, as long as you use those credentials. But simultaneously, 2 people cannot log into the system. Only one person can. But if you want to, you can create 2 accounts. So say your offshore immigration team can create one account and your US immigration team can create another. So in order to do this, you'll have to use a different email address for each, but that's possible. But I would caution you on using 2 different accounts, because then there might be duplicates, because both the teams might register the same person or same set of people. And then remember, if they're duplicates, then both the applications will be denied. It's not that they let you keep one and then deny the other one. So just be cautious when you do that.
That helps. This is a follow-up to one of the previous questions that you answered. Can my spouse convert from B2 to F2 or H1?
Yeah, there's no reason that the spouse has to follow your path. So the spouse can convert from an F2 to B2 as well, or H1 as well, if they have their own employment and they're registered, they get registered under the cap, etc. Absolutely, they can either file a change of status from F2 to B or to H.
Okay. registered with two different companies and selected for two different companies, but H1B filed for only one company, but USCIS needs a NYR, or so is it risky to register multiple H1B?
For the applicant, I'm presuming the question is it risky for the applicant to register multiple H1s? I mean, they are doing it. I have not really seen enough of pushback for people not to do it or to be deterred from doing it. I wish there was. I mean, see, you can't blame them either, because that's how the system is. If you have only 85,000 and there are 400,000 people that need to apply for a H1, then obviously they're going to try to make use of all the loopholes possible in the system. And there are especially the students, the people on F1, if they're F1, if they're completing their course, they're desperate to get on to, work visa, the H1, because otherwise they have to leave the country or they have to join some other course which is expensive. So there is no deterrent as yet. Maybe here and there you get a NOIR, as you mentioned, but system-wide there's no deterrent. But is it risky? For the employer, the risk is not so much for the beneficiary. I think the risk is meant to be, at least based on what USCIS initially said, the risk is meant to be for the employer. If they register and they don't file the application, they might question them as to why they didn't file. But it hasn't happened so far.
Okay, good to know. What is the chance of getting green card after doctorate in computer science? Presently crossed over 54 out of 100 credits. Along with that, I have 48 citations online.
So your case will have to be evaluated to check whether, everybody qualifies for a green card if you have employment. So I think your question is whether you qualify for an EB1 or not, as opposed to an EB2 or an EB3. Or whether you can self-petition. Maybe that's another question.
It's EB1.
EB1, right. So we'd have to look at your resume to see if you qualify. It really depends on, it's possible that you might qualify based on the researcher category, depending on whether you're still doing that research and who you're working for, how useful that research is to the US, and how many publications, citations, etc. that you have. Do you have any patents, etc., etc. So they look at the entire picture, and I think you have to complete I don't think if you haven't completed your PhD you would qualify. I think you should complete your PhD and then give your EB1 a shot. Depending on, of course, you have to continue to be working in that field, in the field of research.
Okay. All right. So, Prashanthi, I would say that's a wrap. Thank you so much for everyone who has joined this session today.